Good morning, Your Honors. The matter before the court this morning is the case entitled State v. Cox, case number 23 AP 273. Representing the appellant, Brian Cox, is Jacqueline Wynell. Representing the appellee, the state of Vermont, is Evan Meenan.
All right, Ms. Wynell, please introduce yourself and identify your client, and then you may proceed.
This is Jacqueline Wynell on behalf of appellant Brian Cox. Mr. Cox's conviction must be reversed. Exculpatory evidence was excluded from his trial, even though this evidence was admissible and could have established reasonable doubt. Mr. Cox was accused of lewd and lascivious conduct at work. At trial, the defense attempted to introduce testimony from two different witnesses that Mr. Cox had a good reputation for maintaining appropriate relationships with his coworkers, but this testimony was excluded. This evidence was clearly admissible under this court's long-standing precedent and the majority rule across the country. Rule 404A1 of the Vermont Rules of Evidence allows a defendant to bring in evidence of a pertinent trait of his character. Rule 405 allows character to be proven through the use of reputation testimony. This court has held that a criminal defendant has the right to bring in evidence of his good character. This court approved the use of character evidence of a defendant's sexual behavior in State v. Parker and State v. Fellows. The appellee's brief has egregiously misrepresented this court's opinion in Fellows. It actually directly contradicts appellee's position. In Fellows, this court held that the defense counsel asking witnesses about the defendant's reputation with regard to his sexual interest in teenage girls fully complied with Rule 404. Here, the proffered evidence was that Mr. Cox had a reputation for maintaining appropriate relationships with his coworkers and a reputation for not engaging in inappropriate behavior at work. Reputation testimony is designed to convey a defendant's past conduct without going into the details of specific instances of conduct. A Third Circuit case cited by the appellee, Government v. Grant, explains that reputation evidence reflects the absence of specific bad acts, the presence of good acts, and general public conduct. The exclusion of this evidence was an abuse of discretion. The Fifth Circuit has even held in United States v. Darland that the exclusion of relevant evidence of the defendant's good character rises to the level of plain error. Furthermore, both of our challenges were preserved for appeal. We challenged the exclusion of reputation testimony from two different witnesses. Our challenge regarding the first witness, Chris Harris, was clearly preserved, and this is uncontested by the appellee. This error is reversible error on its own. Our challenge regarding the second witness, David Hansen, was also preserved. Defense counsel made a proffer of this witness's expected reputation testimony. The trial court stated that it was ruling that this testimony was not admissible. The court gave the defense the opportunity to call the witness anyway and to have the witness potentially testify about other matters, but the reputation testimony was ruled inadmissible. This issue was also re-raised in the defense's motion for a new trial. The trial court denied that motion on the grounds that the evidence was inadmissible under Rules 404 and 405. The trial court had a fair opportunity to rule on this issue, and our challenges were preserved for appeal. Furthermore, the appellee cannot show harmless error beyond a reasonable doubt. Here, evidence of the defendant's good character was especially crucial where the state's entire case rested on the word of the complaining witness. And this court and the United States Supreme Court have both held that relevant evidence of a defendant's good character can be enough to establish reasonable doubt. If there are no questions, then I would reserve the remainder of my time.
All right, I see no questions at this juncture, so you may reserve the rest of your time. Mr. Meenan, please introduce yourself and your client, and then you may proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. I'd like to start off this morning by addressing the allegation that the state has egregiously misrepresented this court's decision in the Fellows case. It's the state's position that that case is actually very helpful in this appeal because it helps define when character evidence crosses the line between reputation testimony and opinion testimony. And the parenthetical following the state's citation to the Fellows case flags that that distinction was very important to the court's holding. The state's argument in this case, distilled to its essence, is that appellant was trying to impermissibly offer opinion testimony that was based on the absence of specific instances of similar prior bad acts. That is not permissible, even when the question eliciting the testimony uses the word reputation. In other words, it's the testimony that was objectionable in this case, and you have to look at the content of the testimony in addition to the content of the question. The state is not arguing, and this is important, the state is not arguing that a defendant may never admit character evidence in sex crimes prosecutions. They can, provided the evidence stays within the confines of Rules 404A1 and 405A. Page 17 of the state's brief makes this clear when it acknowledges that a defendant could, for example, and if the proper foundation was laid, ask whether or not he has a reputation for being respectful. On appeal, appellant asserts that that's what he was trying to do in this case. However, the state respectfully asserts that that's revisionist history. What he wanted to do was get Hansen to say that he didn't have a reputation because he conducted his own investigation and concluded he couldn't form an opinion as to whether or not appellant had inappropriately touched Butcher or anybody else. Then he wanted Mr. Harris to say no because Harris had never actually seen appellant touch someone inappropriately before. However, it's clear that reputation is not what a few persons say or may think about the party in question. It is what the community in general believes. And I think, that we could certainly get into the content of the proffers that were made below, but one of the most revealing statements that shows what appellant was actually trying to do was a statement that his counsel made in the hearing on his motion for a new trial. And that statement referring to Mr. Harris and Mr. Hansen was, they might be able to say there's never been an inkling that he did something like this before, so there's no reputation. That is attempting to equate the absence of specific bad acts with reputation, and the authority cited in the state's brief makes it clear that those two things are not equal. And so what the state is arguing in this case is that the absence of prior bad acts is not permissible evidence of a pertinent character trait. In other words, a reputation for not touching someone inappropriately isn't a pertinent character trait because that isn't the type of thing that the community would have public knowledge of. Now, that might not always be true in a sex crimes prosecution. For example, let's say someone was charged with public indecent exposure. In other words, flashing themselves in a public setting. Well, the community might have some thoughts about that person's reputation for not being the type of person that would do that before. But that wasn't the fact pattern here. And this is really the important distinction. The absence of prior bad acts may be the reason why someone might have a specific reputation, but you can't specifically admit that absence even when laying the foundation for the reputation evidence. Instead, you do two things. You have to establish that the witness was aware of the person's reputation. In other words, how they know the defendant and how they are a member of the community. And then you just elicit the reputation itself. But to do those two things, you don't have to get into, and you're not permitted to get into, the fact that the person had never previously done what they're charged with doing in this particular case. Pardon me. In addition, an investigator is not allowed to testify based on the contents of their investigation that they have an opinion that someone has, or that someone is not the type of person to do what they are charged with doing. The state stands by its assertion that this court's holding in Sturgeon suggests that this court is prepared to adopt that view. And the state again asserts that it did not misrepresent that holding either. And I see that I'm out of time, and I thank you very much for your consideration of this case.
All right, thank you, counsel. Does the appellant have any time remaining?
Appellant has 1 minute and 22 seconds remaining.
You may proceed.
Thank you, Your Honor. So in this case, the appellee's brief did egregiously misrepresent the court's opinion in Fellows. The appellee's brief pushed together quotations from different parts of this opinion. to claim that when the defense asked about the defendant's reputation in the community with regard to his sexual interest in teenage girls, this complied with the rules of evidence minimally, if at all, when actually the court held that this fully complied with the rules of evidence. However, with response to the state's claim that this was opinion testimony, that is simply not the case. Defense counsel actually explicitly told the trial court that witnesses are not allowed to bring in evidence of their personal opinion of the defendant's character, but they are allowed to bring in evidence of the defendant's reputation in the community. Here, both of these witnesses were co-workers of the defendant. Chris Harris was an assistant manager at the Family Dollar store, and David Hansen was the HR manager. And the proffer included the information of how this witness was qualified to testify about the defendant's reputation in the community, that this witness had supervised the defendant for 5 years, that this witness had spoken with all of the co-workers of Mr. Cox, knew Mr. Cox, and was familiar with his personnel record over the past 25 years. And the witnesses are allowed to rely on all of that hearsay information in order to testify as to a person's reputation. And the proffer was regarding the reputation evidence of the defendant and not opinion testimony.
All right, and you'll have to leave it there. You're now out of time. All right, and the bailiff may call the conclusion.